Silence. All stand and remain standing until the conclusion of the reading of the proclamation. Ladies and gentlemen, the proclamation. All persons having any business before this honorable court now draw nigh. Give your attendance, and you shall be heard.
Chief Justice, I have the honour to announce that I've been appointed a judge of this court. I present to you my commission.
Thank you, Justice Boulten. Please be seated while the commission is read. Principal Registrar, I hand you the commission to be read.
By Her Excellency, the Honourable Margaret Beasley, Companion of the Order of Australia, King's Counsel, Governor of the State of New South Wales in the Commonwealth of Australia. To Phillip Richard Boulten, Barrister at Law, greeting. Whereas by the Supreme Court Act 1970, it is enacted that the Governor may, by commission under the public seal of the state, appoint any qualified person to be a judge of the Supreme Court of New South Wales. Now I, the Honourable Margaret Beasley, AC, KC, the Governor aforesaid, in pursuance of the power and authority vested in me in that behalf, do, with the advice of the Executive Council of New South Wales, hereby appoint you, the said Phillip Richard Boulten, being a person qualified to be so appointed, to be a judge of the said court on and from the 3rd day of February 2026, with rank and precedence as such in the said court and in the aforesaid state, next after the Honourable Justice James Stewart Emmett, one of the judges thereof, provided always that you shall, except in case of leave of absence duly granted to you, actually execute the office to which you are by this commission appointed. Given under my hand and the public seal of the said state, this 11th day of December 2025, Margaret Beasley, Governor. By Her Excellency's command, Michael Daly, Attorney General.
Principal Registrar, do you have the form containing the affirmations? Thank you. Justice Boulten, I ask you to rise and take the affirmations of office. First, the affirmation of allegiance, and then the judicial affirmation.
I, Philip Richard Boulten, do solemnly, sincerely and truly declare and affirm that I will be faithful and bear true allegiance to His Majesty King Charles III, his heirs and successors according to law. I, Philip Richard Boulten, do solemnly, sincerely and truly declare and affirm that I will well and truly serve our Sovereign Lord King Charles III in the office of Judge of the Supreme Court of New South Wales, and I will do right to all manner of people after the laws and usages of this state, without fear or favour, affection or ill will.
Thank you. I ask you to resume your seat to sign the affirmations, after which I will attest them. Principal Registrar, I hand you the affirmations to be placed amongst the court's archives. Justice Boulten, we met many years ago when I had the honour to serve under you as President of the Bar Council. I formed the view then, which I've held ever since, that you're a man of the utmost integrity. And I am very pleased that you're joining this court and look forward to you deploying your great and rich experience, particularly in the criminal law, in the public service of the state. I thank you for accepting the appointment and welcome you to the court.
Thank you, Chief Justice.
Mr. Toomey, do you move?
May it please the court. I acknowledge the traditional custodians of this land, the Gadigal of the Eora Nation, and pay my respect to elders past and present, and to any First Nations colleagues here today. It is my privilege and a personal pleasure to speak for the Bar on this, the occasion of Your Honour Justice Boulten's swearing in. The judicial oath Your Honour just took has ancient roots and is now the solemn promise required by our Oaths Act to be taken by all those assuming judicial office in this state. Its words were chosen carefully. Contained within the words is an implicit recognition that judges are humans, not automatons, who are drawn from life and not from a void. As people who are both generally educated and learned in the law, which of course entails a deep understanding of the organs of our democracy, it is to be expected of anyone assuming the office Your Honour just has that they will have strongly developed political and social views. That Your Honour has such views and has from time to time expressed them ought to be regarded as unexceptionable. Your Honour is abundantly well qualified to join the bench. You are undeniably one of the preeminent criminal silks in the country, described by many as a national treasure and a living legend. This is undoubtedly the view shared by your many friends and colleagues who are here to support and celebrate your appointment today. Throughout your career, you have gravitated to difficult, often unpopular and complex cases, defending some of the most vulnerable and indeed sometimes reviled in our community. You have, for many years, championed the rights of First Nations people and been driven by a commitment to equal access to justice. Your Honour has built an illustrious career from suburban beginnings. In the 1970s, you worked as a clerk for a suburban solicitor while studying law at the University of Sydney. You went on to join a law firm in Revesby, where you had grown up, and later took up roles with the Public Solicitor and the Legal Aid Commission, where you practiced exclusively in criminal law. In 1988, you were called to the bar and helped found Forbes Chambers. Forbes became Sydney's first specialist criminal law floor and remains the first port of call for many who require representation in that field. You are described as part of the heart and soul of Forbes, from where you have mentored many barristers and solicitors. In 2003, Your Honour took silk, with your practice spanning every stratum of the judicial hierarchy, from the local court to the High Court. To read your CV is to traverse hundreds of the most complex and highest profile criminal trials, sentences and appeals in recent decades. Perhaps chief among them is your defence of Solicitor Bernard Collaery in the ACT Supreme Court and Court of Appeal in the fallout following Australia's Timor-Leste spy scandal. A sample of Your Honour's High Court appearances includes Hughes and the Queen, resulting in a significant judgment concerning tendency evidence, and Roy and O'Neill concerning the exercise of police powers on private property. In the New South Wales Court of Appeal, Criminal Appeal alone, you have appeared in some 180 matters, including MacDonald and the Queen, Kaloa Matangi and the Queen, and Curran and the Queen, just to name a few. You have also acted in numerous terrorism, foreign bribery, drug importation, corruption, and murder trials in the Supreme Courts of New South Wales, Queensland, and the Northern Territory. Notable New South Wales trials include the Queen and Zach Malla, the first person prosecuted under Commonwealth terrorism laws, and the Queen and Dugar, Reid, and Link, which involved allegations of foreign bribery. Your Honour defended Harriet Rann when she was charged with extremely serious offences, and Susman Sood, who was charged over an illegal abortion. This, of course, is a tiny sample of an extraordinary breadth of matters which could, quite literally, keep us here all day. I promise not to do that. Your Honour has said criminal law is about structural justice. You always remember it is a human system dealing with real people whose paths to their intersection with the criminal law are many, varied, and often trace back to extreme disadvantage. Some of the significant inquests and inquiries you have worked on include the Royal Commission into Aboriginal Deaths in Custody, the Wood Royal Commission into the New South Wales Police Force, and as counsel for the family of Katrina Dawson, a much-loved member of the New South Wales Bar following the Lint Cafe siege. You have also represented barristers and solicitors during disciplinary proceedings, as well as appearing for various jockeys, horse trainers and greyhound trainers before the Racing Appeals Tribunal. The juxtaposition between those two classes, barristers and jockeys, is deliberate. You have derived particular satisfaction from your pro bono work for Aboriginal clients in the Northern Territory. Each year, you have spent about 6 weeks in the Territory representing clients of the North Australia Aboriginal Justice Agency, or NAJA. You appeared for NAJA during the Don Dale Royal Commission and at the inquest into the death of Kumanjai Walker. In the finest traditions of the bar, you have taken any case they've given you, from murder trials to the local court bail list. Recently, you flew up during a cyclone to run a case, landing just before the storm hit. It is this unwavering commitment to justice, combined with an admirable humility, that has earned Your Honour the deepest respect of both colleagues and clients. Your Honour has, in short, made an extraordinary contribution to the administration of justice and the rule of law over decades. This is evidenced by your numerous senior roles, including as a bar councillor, culminating, of course, in your presidency of the New South Wales Bar Association in 2013 and 2014. I had the privilege of being on the Bar Council during Your Honour's presidency and observed your humility and ability, of which many speak. I'm truly grateful to Your Honour for the service you gave and the example you set in that role. For the last 2 decades, you have been on the Law Council of Australia's Criminal Law Committee, and in 2019 received the LCA's President's Award. You have been praised by your peers for possessing an unparalleled discretion, humanity, and decency. They describe you as a tactical genius in the courtroom and someone with an immense insight into people, justice, and the real-world consequences of the law. Despite everything you have achieved, you remain, as I have already observed, utterly unpretentious and grounded. You have expressed to friends and colleagues that you feel honoured to have been offered this appointment and are confident you will bring a calm, considered judgment to the bench. I share Your Honour's confidence. Outside the law, your primary passion is art, particularly contemporary and Aboriginal art. Your partner, Joe Holder, is, of course, a respected gallerist and curator who directs the Cross Arts project in inner Sydney. She once described you as her advisor extraordinaire. You both know many artists and curators across the country and spend a good deal of time visiting remote art centres and communities. Beyond art, you and Joe do everything together: travelling, swimming, Pilates and yoga. The New South Wales legal profession and broader community is indeed fortunate to have someone of Your Honour's experience, intellect and humanity on the bench. I have no doubt your time as a judge of this court will be marked by the same excellence and integrity which has been the hallmark of your career to date. Your Honour has the bar's congratulations and well wishes. May it please the court.
Thank you, Mr. Toomey. Mr. McSweeney, President of the Law Society of New South Wales.
May it please the court, I too acknowledge the Gadigal of the Eora Nation, the traditional owners on the land on which this court stands, and I pay my respects to their elders, past and present. I acknowledge and extend my respects to all Aboriginal and Torres Strait Islander peoples who are with us today. It is my privilege to offer the congratulations of the New South Wales solicitor profession on Your Honour's appointment. Your Honour, you enjoy an enviable reputation amongst the profession. You are remembered as a valuable friend who is extraordinarily selfless and a barrister with a good heart and a good sense of humour, the epitome of a barrister, according to one solicitor. The Law Society was told that Your Honour would go wherever it was needed, and often, as we have heard, that was the Northern Territory and the Aboriginal Legal Service. A fellow barrister at Forbes Chambers said, and I quote, "I know of no other barrister who has committed the same amount of time and resources to pro bono assistance as Phil Boulten. As we have heard, Your Honour has spent a substantial amount of time rendering this pro bono assistance in the Northern Territory, representing Indigenous clients, where Your Honour was known to be able to get through extraordinary volumes of cases with genuine enthusiasm and joy. And during one of these trips to the Northern Territory, Your Honour enjoyed a night out with your colleagues. Our informant told the Law Society that she had, after many refusals, finally convinced Your Honour to go clubbing with them. And for the court record, that's right, I said clubbing. Your Honour is, and here I am quoting this barrister, straighty 180, and you did not share the enthusiasm for the 3 a.m. nightclub scene. Still, everyone was thrilled to have you join them. Your Honour did not dance, but did observe with interest the tableau, most likely wondering whether the nightclub's dancers were in their cages willingly or had been caged following a fair trial. Your Honour's unceasing dedication to justice is indeed an inspiration. To put Your Honour's mind at ease, I will assure you that I have not been permitted to see the top secret photo from that night. Your Honour's time in the Northern Territory was not only spent in courts and nightclubs, though. As we have heard, Your Honour, along with your partner Joe, is immersed in contemporary and Aboriginal art. Your Honour even serves as secretary of the board of Artback NT, an organisation which brings Northern Territory artists together with audiences. This love of art thrives alongside Your Honour's now former talent as an advocate. The Law Society heard that following one successful cross-examination, a junior barrister called the effort a masterclass. Your Honour said, "I don't know about that, but I think we got what we needed." This is typical of Your Honour's reputation, well regarded by your peers, but always with humility. Another barrister called you a bit of a father figure, interested in professional development and the well-being of your colleagues. He's tough. He's no milquetoast, which, for those not up to date, is a cartoon character from the 1930s. On a more positive, perhaps less obscure note, she added, "We all aspire to be like him." The solicitor who first met Your Honour early in his career said, and I quote, "I blame him for keeping me in the law." You told him that if he loved the law now, he always would. This turned out to be true for him. Your Honour made a considerable impression on this solicitor. He admired your work ethic and has striven in his career to emulate this. Although he also told the Law Society that of an instance, just one, when Your Honour, outside court, Your Honour jumped up and down like Yosemite Sam, fingers pointed in the air like guns upon winning a case. This solicitor has not said whether he has emulated this particular behaviour. Behaviour that is more widely known has, of course, been Your Honour's belief in the first cab off the rank rule. Former clients, including for individuals like, say, Chris Dawson, showed willingness to take on clients whom public opinion, I think it is fair to say, was largely against. Footballer Jared Haynes and Hey Dad star Robert Hughes also number among your clients who've contended with widespread vilification, not only in mainstream media, but in social media. But Your Honour was certainly not afraid of a difficult case and presented with all your legal ability for every client. Your Honour defended barrister Bernard Cleary, as we have heard, on charges that he conspired with his client to disclose classified information regarding the Australian Secret Intelligence Service spying operation in Timor-Leste. When Gilbert and Tobin considered representing Mr. Cleary, Your Honour was immediately considered to lead. Your Honour agreed to take on the case pro bono, having already reached out to Mr. Cleary with the same offer. Your Honour's defence was constrained by secrecy requirements so severe that The Guardian reported it was necessary to obtain government approval to view evidence against Mr. Cleary. This was just one of the obstacles to Your Honour's work in this trial. Despite these difficulties, the prosecution was dropped in 2022, 4 years after Mr. Cleary was first charged. Casting his mind back, Bernard Cleary recalled that Your Honour had addressed the 2016 Northern Territory Bar Association conference in Timor-Leste. "He struck me as immensely wise," he said. "Phillip's address was timely, diplomatic. He is a quiet, modest, and brilliant advocate." Another solicitor who has instructed Your Honour told the Law Society that given the community's high expectations of the judiciary, courage is one of the most important qualities its members need. He recalled an incident amid an application for a permanent stay of an indictment for Chris Dawson, in which he instructed Your Honour the application was thoroughly prepared over 20 A4 folders of evidence and a brief exceeding 14,000 pages. Towards the end of the evidentiary stage, after some weeks, Your Honour collapsed at the bar table while addressing Justice Fullerton. Your instructing solicitor caught you, and he, along with the Crown prosecutor, his instructing solicitor, and Her Honour's staff, rendered assistance. Thankfully, this was assessed to be a relatively minor issue. Your Honour informed our solicitor on the following Saturday that you wished to proceed with the submissions. He urged you to reconsider. Surely an adjournment for a week would be in order, but Your Honour's mind was made up and you devoted the Sunday to preparation. There's that work ethic again. The Law Society was told that on the Monday, Mr. Boulten rose at the bar table and commenced the final address. Apparently, Justice Fullerton suggested that you sit while addressing the court, but Your Honour stood, continuing the address for the next 3 days. This solicitor was moved by this display of courage and determination, and it has remained with him since. Your Honour's experience as a defence barrister and your curiosity have given you insights into humanity that will be a tremendous asset in your career on the bench. You have shown yourself to be willing to listen to those already judged guilty by others and discern the issues of a case to see them clearly. Your Honour takes seriously the presumption of innocence which is afforded to all of us. Over a highly regarded career at the private bar, Your Honour has shown yourself to be one of the best criminal lawyers in our state, with a mind fit for the rigours of this bench. Your Honour, on behalf of the 44,000 solicitors of this state, congratulations on your appointment to the Supreme Court of New South Wales, as the court pleases.
Thank you, Mr. McSween. Justice Boulten.
Thank you, Mr. Toomey. Thank you, Mr. McSweeney. Your generous words are very welcome. I'm deeply honoured by them. I also acknowledge the Gadigal people who have been the custodians and chroniclers of this land for millennia. Their ownership and connection to this land continues without ever having been ceded. I pay my respects to all Aboriginal and Torres Strait Islander people who are here today. Thank you, Chief Justice, for your encouragement, and thanks to everyone, all of the judges, some of the former judges who have welcomed me to this court. Thanks to everyone for being here today. This is a magnificent turnout, including the people who are online, and your presence is also a great encouragement to me. The support for my appointment almost overwhelmed me. Thanks to the New South Wales Bar Association. Thanks to the Australian Bar Association for your backing in recent times, especially to the President, Mr. Toomey, and to the President of the Australian Bar Association, Michael Izzo. Thank you very much. I value this court's integrity. I am honoured to be sharing office with so many excellent judges. The Supreme Court is fundamentally important to our stable democracy. As the third limb of our system of government, the judges' decisions are a significant check against attempts at untrammelled power. It has always been so. But in this febrile time in the affairs of nations, where evidence is often disregarded or derided, where truth is whatever it is called to be, and where the rule of law is often a hindrance to the powerful, it is necessary to have a strong system of justice which people regard as sound and reliable. We have it here in this court. The court's administration of criminal justice is especially important. I hope to use my experience to benefit the court's work. We celebrated the court's 200th anniversary in 2024, but in the context of the long history of the peoples of this continent, the Supreme Court is a very recent phenomenon. Gadigal people lived here under highly structured systems of custom and law for tens of thousands of years before the court existed. It is also important to recognise that the dispossession and dispersal of Aboriginal peoples from their lands was commonly accompanied by violence and murder, often at the hands of state actors. This history, in my opinion, is relevant in dispensing criminal justice. It is one of the causes of the enduring gap between Aboriginal lives and the lives of non-Aboriginal people. serious disadvantage and racial profiling ensure that the Aboriginal people are much more likely to be caught up in the criminal justice system. Aboriginal people comprise more than 30% of the adult prison population in this state and 50% of the youth detention population, even though they constitute 3% of the total population. Over the last 5 years, the number of Aboriginal people in custody rose by almost 20%, while the non-Aboriginal prison population declined. The number of Aboriginal young people in detention increased by about a third. In the Northern Territory, the situation is catastrophic, where Aboriginal people represent about 85% of the prison population, and the kids in detention are almost exclusively Aboriginal kids. Jail is a dangerous place. Last year, 12 Aboriginal people died in custody in New South Wales. And since the Black Deaths in Custody Royal Commission, there have been a staggering 620 Aboriginal and Torres Strait Islander deaths in custody nationwide. Quite evidently, in our justice system, there is a structural imbalance based on race, as was recognised by the authors of the Uluru Statement from the Heart. Quote, proportionally, we are the most incarcerated people on the planet. We are not an innately criminal people. Our children are alienated from their families at unprecedented rates. This cannot be because we have no love for them, and our youth languish in detention in obscene numbers. They should be the hope of our future. These dimensions of our crisis tell plainly the structural nature of our problem. This is the torment of our powerlessness. Unquote. This structural imbalance influenced the shape of my practice. In my earliest years at the bar, I appeared at the Aboriginal Deaths in Custody Royal Commission for a family of a young man who died in police custody. One of my role models, Steve Norrish, was counsel assisting. Then I was briefed by the Western Aboriginal Legal Service to appear in trials in Western New South Wales. That's when I met Dina Yehia, a superlative Walls lawyer. I shared Walls trial work with people like Peter Hamill, Ian McClintock, and the late John Terry, who I first met when he worked as a solicitor with Virginia Bell at the Redfern Legal Centre, and I was a student volunteer. Since then, I've participated in so many inquiries into the treatment of Aboriginal people, both in New South Wales and in the Northern Territory. Peggy Dwyer and I represented Ngarjar at the Don Dale Royal Commission and more recently at the inquest into the death of Common Walker, as you've heard. Yet despite nearly 4 decades of clear and unambiguous recommendations made by Royal Commissions and coroners, there has been no improvement in the lot of Aboriginal people in the criminal justice system. Legislators continue to ignore this evidence and reject findings. It's still happening now in this state and in the Northern Territory. The most emotionally effective and intellectually stark depiction of the futility of these inquiries is Archie Moore's magisterial work, Kith and Kin, the winner of the Golden Lion Award at the last Venice Biennale. The artist is a Gamilaroi and Binghamble man from southwestern Queensland. I viewed this monumental work in Brisbane last year. Its centrepiece is a memorial comprising the piled white pages of volumes of transcripts, reports and judgments about Aboriginal deaths in custody sit adrift on a pool of dark water. And surrounding this memorial on the room's black walls is the artist's family genealogy written in white chalk, disappearing into infinity. As I looked at the bundles of transcripts in the middle of the room, I identified cases I'd appeared in, bringing home to me that the accumulated learning from these inquiries is adrift on a sea of forgetfulness. Here I pay tribute to all the lawyers who work for and on behalf of Aboriginal and Torres Strait Islander peoples. The Aboriginal Legal Service solicitors in this state do an amazing job. They are the best of us, as are the lawyers at NAJAR. Thank you to two former NAJAR principal legal officers and my friends, Judge David Woodruff and Nick Espy, for allowing me the privilege of working for their clients over the years in every imaginable forensic context. These two magnificent Aboriginal lawyers have led the profession in continuing the struggle for justice for First Nations peoples. I hope to help contribute to the work of this court in the delivery of justice to Aboriginal people. I believe that because Aboriginal powerlessness is at the heart of the structural imbalance, Aboriginal-led solutions are the key to restoring balance. I am solemnly bound by the promises that I made this morning. I will work to dispense justice fairly and independently to everyone in civil cases and in criminal cases. Barristers are independent, bound by the cab rank rule. I always treated everyone with respect, irrespective of their ethnic background, religious beliefs, political beliefs, sexual and gender orientation, or their status in the community. I will bring this independence to my duties as a judge. I've always practiced amongst great people, playing incredible roles as lawyers. In my early career in the public solicitor's office, I worked with many solicitors who went on to careers at the bar as public defenders or as members of the private bar. One was Darryl Mellom. We met in our first days at university. I followed him into the public solicitor's office. Darryl became a public defender, and then for 23 years he was the member for Banks in the Federal Parliament. Banks is where we both grew up. He's my brother. His family are my family. It was a great honour for me, actually, hailing from the Bankstown area, to go on to be the bar's president. The Bar Association has always been a crucial contributor to the rule of law in this state, as has the Law Council of Australia in the federal sphere. The Law Council plays an influential role in helping to shape Australian criminal laws and is often able to bring lawyers' experience to bear to avoid unintended consequences. An excellent example was in the early 2000s when the Law Council, through Sarah Pritchard's brilliant analysis of human rights norms, developed a crucial policy paper in response to the government's draft terror laws, which helped the Parliament over months to appropriately moderate the proposed legislation. I have shared chambers with some magnificent barristers, initially at 4 Wentworth, thanks to Anna Katzman's generous support, then at Frederick Jordan, where I practiced with the likes of the storied Elizabeth Fullerton, Malcolm Ramage, Mark Irace and Greg James, all friends. In 1990, I moved with 27 others to set up Forbes Chambers, which has grown to be the preeminent criminal practice in Australia, in my humble opinion. I single out one Forbes member whose example I tried to follow, the late, great Paul Byrne SC. I admired Paul's quiet, persuasive advocacy, his strength in the face of formidable opponents, and his dexterity as a lawyer, comfortable at all levels of the court hierarchy. For 40 years, Tim Game and I have worked together with great respect, and with successive boards, we've encouraged excellence in our floor colleagues. I want to thank all of Forbes Chambers staff, especially to our clerk, Ryan Calero, who provides dedicated service to us all. He's steered us with great skill, just as, when he was the floor junior, he mastered the art of making the DX deliveries on his skateboard. I pay special respects to our librarian, Michelle Crozier, and to our wonderful juniors, usually struggling law students, some of whom are now successful lawyers and one a judicial officer. Thank you to Kim Nguyen. You've given many years of excellent support as my PA. I employed Kim in 1985 as secretary at the Bankstown Legal Aid Office. At Forbes, she successfully negotiated the challenge of juggling my work with the competing and at times formidable demands of her other employers, Tim Game and David Buchanan, not to forget Elizabeth Fullerton. Importantly, the number of women barristers continues to rise, including at Forbes Chambers. It has been an honour to work with so many gifted women in so many cases, some of whom are now silks. I mentioned Gabby Bashir SC, who was one of my early readers and also went on to become the bar president. And I also mentioned other female juniors who've gone on to appointment as silk: Kirsten Edwards, Peggy Dwyer, Angela Cook, Julia Roy, and others, no doubt. I'm looking forward to receiving the same assistance from those people in court as they gave me when we worked together as counsel. Thanks also to my excellent colleagues at both 8 Petrie Terrace Chambers in Brisbane and at Mindle Chambers in Darwin, where I was welcome in both places when appearing in their local courts. I acknowledge my good friend David Dalrymple, who introduced me to practice in the Northern Territory. He is now one of the senior Crown prosecutors in Alice Springs. I also wish to acknowledge my close professional relationship with Sean Bowden, a great Darwin lawyer who, with Denise Bowden, the CEO of the Yothu Yindi Foundation, opened the door to me to meet Gumatj people and to learn from their powerful and continued Yolngu culture and customs. In a similar way, I acknowledge my cultural guide, Marion Scrimgeour, who introduced me to her community on the Tiwi Islands and to the rich cultures of Central and Western Arnhem Land. I also thank Will Stubbs, a former criminal lawyer who burnt his suit when he moved to Yirrkala to run the Bukulonge Mulka Art Centre. His knowledge of Yolngu art has been inspiring. Experiencing Aboriginal culture has convinced me of its central importance in the process of eliminating the overrepresentation of Aboriginal people in custody. I've worked with many fine solicitors, far too many to mention them all, but some deserve a shout-out. David Giddy always worried our cases into good shape. Our clients always benefited from David's devotion to detail and his rigorous testing of my strategic decisions. Greg Walsh and I have weathered many storms together. At one stage, we had a hearing in the High Court early in the week before 7 judges, who you heard about, who were considering the meaning of the concept significant probative value in the tenancy evidence law. Then 2 days later, we were impanelling a jury in the Alice Springs Supreme Court where we were defending a client charged with a gangland murder. We lost in Canberra 4-3, but we did win in Alice Springs. I've shared enduring and trusting professional relationships for decades with many solicitors, including Bill O'Brien, Chris Murphy, Abigail Bannister, Martin Ritchie, Penny Musgrave, Greg Gould, Michael Blair, Paul Harden, and Vivian Evans and her colleagues, but there are many more. Brian Wrench and his team at Murphy's sent me to almost every court imaginable. Brian is an extraordinary solicitor devoted to his clients. The media describes him as high profile. Indeed, he is. People would often look at the two of us walking to and from court, and I could tell by the way they were looking at us that they were wondering, who is that fellow with Brian Wrench? And what crime has he committed? Thanks also to Peter Hodges, quiet but relentless, who instructed me to act for his clients facing significant challenges to their liberty, to their reputations and to their careers. In my cases involving national security issues, the courtroom was always full of lawyers, all seemingly pitted against the accused's interests. The solicitors and my junior colleagues in those cases needed to be particularly brave and resilient. In the early terrorist trials, I had enormous support from Adam Hooder and Michael Doughty, and my junior, Peter Lang, now at last, Peter Lang SC, in Sydney, and in Melbourne, Robert Starry, the late Peter Murphy, who went on to become the federal member for Dunkley, and Fiona Todd, who is now a distinguished county court judge. In the trial against the alleged leaders of the Tamil Tigers in Melbourne, I worked with Michael O'Connell SC as co-counsel, with whom I later shared the important responsibility of representing Katrina Dawson's family. Michael is now an esteemed county court judge. More recently, in Bernard Caleri's trench warfare against the Commonwealth, the magnificent Kate Harrison and Chris Flynn from Gilbert and Tobin provided indefatigable and sage helmsmanship to me, Chris Ward and Rose Kalilizadeh. Meanwhile, most recently, I was working with Karen Espiner on the first war crimes murder trial that's about to be conducted in this court. Away from the law, Jo Holder has been the best personal art curator in Australia. She is the most patient and sympathetic partner, listening to endless stories about my cases. To be fair, I've also been open to her influence, especially to matters concerning art. Art, artists, curators, writers, they've all helped to put my own work into a wider context. I thank our dear friends from the art world and our families who came here today. I'm not going to be the longest serving judge of this court, but whilst ever I sit in this court, I dedicate myself to the delivery of justice. Chief Justice, I'm ready to start.
Well, the court will now adjourn to enable you to do so.
All stand. This honourable court is now adjourned.